Okay, the legal demand for papers is back. And it is back in the Jones versus Abel case, the separate Jones and Jones Works versus Abel and Wayfair and Everybody case, in which Abel and Wayfair and Everybody have also filed counterclaims back against Jones. So a motion to compel was filed yesterday in that matter on behalf of Jennifer Abel, asking the court to compel Van Zandt, the company, to provide documents related to the legal demand for papers, including the legal demand itself, which they still have not seen. That is insane to me. So this seems like the smartest place to seek these documents in this particular case, because Jennifer Abel has a specific actually several specific counterclaims based entirely on the fact that Stephanie Jones took this data off of her phone and then handed it over to somebody improperly. So she's alleged a whole bunch of different claims of like Stored Communications Act and wiretapping statutes and all that kind of stuff. So this is probably the right place to bring it. But in reading this motion to compel, we get some information about what has happened thus far in terms of the parties talking about and trying to get their hands on the legal demand and all the information surrounding it. So what we learn from this motion, and the person who wrote this motion, by the way, is that woman, Ellen Garofalo. Just always makes me think of Janine Garofalo, my 90s kids, shout out. She's the one who worked at Venable like a long time ago, and then she worked at Carlton Fields, and now she works for Friedman. So I don't know that she has any specialized knowledge because she worked at Venable one time. But she's a very well-regarded litigator. What she says in this motion is, they asked Jones, the party in the case, for a copy of this subpoena in March. And they still do not have it. March 2025. So they asked Jones for the information. They didn't get it. So they decided to ask for the information directly from Van Zandt as a third party that allegedly sent this legal demand for papers. So the motion to compel is to compel that company to turn over not only the legal demand, but a bunch of stuff about how that legal demand came to be, and also about the organizational structure of that company. Now, that company has its own lawyers. You can see in the documentation that it is being treated as a totally separate entity. It has lawyers representing it that are not Blake Lively's lawyers in the main litigation. So it is being treated as a pure third party subpoena, just like the ones we saw yesterday with the third parties who are people who used to work at TAG. So this is being a third party subpoena was served upon this company to say, please turn these things over. They are relevant to the litigation. Now you can see in the motion that they've done what they're, you have to meet and confer and try to narrow stuff down. And they've actually narrowed it down pretty far. If you look at the original subpoena and everything that was asked for, it was an awful lot. And the Able lawyer was like, listen, we've narrowed it way down, and they have narrowed it down to only a few categories, and there's only a few things left. The few things that are left is the legal demand itself, the documents they produced in response to the legal demand, communications about the lawsuit that the legal demand came out of, the organizational structure of the entity, and who the shareholders in the entity are. That's what they are trying to compel. They have narrowed it down to that. Now, what I can glean from the motion is that the company's objections to turning over this information are kind of all over the map. They've claimed attorney-client privilege and work product, and that's probably fair for some of it, like communications about the lawsuit, I don't know, but you still have to provide a privilege log. They've said you need to get this from Jones. Don't get it from us, we're a third party. You need to get it from a party, and that party is Jones. So Abel's lawyer's like, well, we tried and she didn't give it to us. And even if she did, because our claim is that she engaged in shady activity, we don't trust whatever copy she's going to give us. We need to see them both. We need to see the original and we need to see what she got. The other argument that the company is making is that this is an undue burden. That's dumb. How is this an undue burden? How much information can it possibly be? It's a company that, as far as we can tell, didn't do anything except file this lawsuit. The response to that by Abel is, first of all, we asked Jones and she didn't respond. Some of this stuff is stuff that only you would have. Jones doesn't have the organizational structure of this company. She doesn't have information about who the shareholders are in this company. And then Abel says, to the extent that this is confidential information, that's what we have an AEO for. That's what we have a protective order for, which, once you get it, then you can't really say, I'm not going to turn that over, because you have a mechanism in place that allows for information to be protected if they are concerned about confidentiality. So they are asking the judge, Abel, through her lawyers, is asking the judge to compel Van Zandt to turn over the legal demand itself, the documents that were produced in response to it, communications between Van Zandt and Jones about the commencement of that action, organizational structure records about Van Zandt and who its shareholders are and how much they own. That's what they are compelling the court to turn over. And I've been trying to think about what the response will be from the lawyers for this entity. And I don't think undue burden is going to get them anywhere. There might be some privileged stuff in there. There might be some privileged work product communications. That's fine. But the subpoena itself, the legal demand itself, cannot possibly be protected information. I just don't see how that's possible. And the fact that they are fighting this is really strange. I mean, one of the things that Abel's lawyer says in her motion is, it's undisputed that this is what happened, and they attach, here's an article from Deadline quoting Lively's lawyers, confirming that yes, this is the case, and yes, this is what we did, and it's totally normal. So it's not as if it's in dispute. So we'll have to see what the response is. But it seems like a pretty strong motion, especially because they have narrowed it down. I had a brief moment there where I thought, God, is there no subpoena? Maybe one doesn't actually exist, so they can't turn it over. But then why go through all the trouble? I don't know. But, the lawyer says, one of the things we're trying to figure out is, had she already turned over the data and then the subpoena was supposed to clean up something that had already been done? Or did she only turn it over once the subpoena got served? And we don't know that until we've seen the subpoena itself, because we know the date that these things were turned over. So it goes to a fair issue in the Jones case. Now, the only fly in the ointment here is that these very same claims that Abel's lawyer is saying this information is relevant to are right now under a pending decision by Judge Lyman to dismiss them. Jones filed motions to dismiss all of these counterclaims. So if he dismisses the counterclaims, then this information is arguably not relevant anymore to this case. I don't know what he's planning to do there. I don't know if he is still working on it. I don't know any of that. But that's the biggest obstacle, I would say, to this motion being granted, is the fact that if the judge says, well, I'm going to dismiss those claims out of the case anyway, why do you need this stuff? But this is all the information that we have all been looking for. This is all the information that we want about how all this went down. And it does appear that both Jones and whoever it is that represents this company are stonewalling it, which is interesting, considering that their public statements are, especially the people who've been yelling at me, you know who you are, that this is totally normal standard practice and everybody does it. Crazy why you wouldn't turn it over then. So let's see what the response is. They have to file a response within a couple of days, but the issue is here. We're litigating it.